Morning, class. Hello, class. Can you hear me?
Yeah, we can. Good morning,
Yes,
sir.
sir. Good morning, sir.
All right, good morning. I would like to welcome us to this class. And by virtue of the content, the course content for this course for this semester, we'll be looking at the topic that is already set before us. And I want to believe you can see the slide. Hello, class. Can you see the slide?
Yes, we can, sir.
All right. Okay, so we're going to start right away. And with this topic, we want to embark on a critical journey on the on African jurisprudence, and at the same time, we will look at the challenges and the wrong assumptions that have been put forward on the subject of discourse. And one of the main purpose of examining the topic is to reclaim what we call the indigenous perspective and to also reposition Africa within the global legal and philosophical discourse. Now, the concept of law in Africa has been wrongly portrayed, and that speaks of the negative thoughts and view that African jurisprudence or law or legal system is inferior. Apart from being inferior, that is it's primitive, or again that there's nothing like African jurisprudence. We've seen view that there's even no philosophy or law worth studying about Africa. And that's why the topic of discourse becomes more important to us. Now, these views or perspectives are quite incorrect. Apart from the fact that they are incorrect, they've also led to misrepresentation of the African nation, of the African legal jurisprudence. So, but the truth of the matter is that African jurisprudence tells a different story, one that is rich in legal customs. And that's one of the reasons why restorative justice is part of our fundamental or one of the most important values that we hold dearly. Again, African jurisprudence is uh, embraces or is community-based. It embraces community-based norms and a deep reference for human dignity, spirituality, and communal harmony. And it is a jurisprudence that is rooted in oral tradition. And because you talked about communal harmony, we also speak of the fact that African jurisprudence is rooted in collective responsibility and ensures balance of the interest of everyone living in the society. It's different from the adversarial system or the adversarial litigation, or what we also refer to as abstract positivism. So, as we will see in this course, we will see the uniqueness of African jurisprudence as against the wrong notion which has, have been held by some particular set of scholars or individuals. So we will examine traditional justice system. We'll look at the role of elders and the council in African jurisprudence. And that will also push us forward to look at the interplay between religion, culture, and law. And again, how the colonialism disrupted our legal heritage. But the joy we share that we still maintain is the fact that despite the wrong views about African jurisprudence, despite the colonialism or our colonial history, still very much intact, not been erased by any wrong perception or views. So we constitutional order and human rights frameworks across the continent. But basically speaking, our goal is to reimagine the legal knowledge from a standpoint that African jurisprudence is authentic and it's unique in its own perspective. That African jurisprudence is unique in its own stand and can stand alone without, looking at how to compare it with other jurisprudence. So, but before we delve into that seriously, I want us to look at hello class. Can I have a confirmation that you are with me?
Yeah, we can hear you,
Yes,
sir.
Yes, sir.
All right, thank you very much. So, from what we have on the slide, African jurisprudence is a branch of legal philosophy that seeks to understand, analyze, and theorize about the nature, sources, principles, and the purpose of law in African society, both traditional and modern. Okay, so with that, we begin to have an understanding of what the topic really is all about. And the second part of the definition that I've put before you says that African jurisprudence refers to the study and philosophy of law as it originates in, is practiced within, and reflect the values, beliefs, and worldview of African societies. And then we will see from this definition that African jurisprudence is not just about law as it is written in the statute books or even in the constitution, but how law, affect the society or how law shapes the society. And at the same time, the interaction between culture, the tradition, community, values, and all of that. These are the basic things that African jurisprudence embraces. So, in the course of this class or this dealing with this topic, we will look at the following subtopics. This will include thinking about law in Africa, we examine, under that, we'll look at the African concept of law and jurisprudence. In the African perspective, what is law? And how do we view our own legal jurisprudence? We will also look at jurisprudential throwbacks or traditional concept of law and justice in Africa. Thereafter, we'll consider jurisprudential throwbacks on some concepts such as constitutionalism, due process, separation of powers, checks and balances, and so on and so forth. Of course, by the time we are done in examining all of these subjects, it will further strengthen the position that African jurisprudence on its own is unique and can sufficiently stand on its own without any individual, any scholar trying to present or to misrepresent the concept of African jurisprudence. Also, in the course of this topic, we will look at the trajectory of African jurisprudence in the 21st century. And we will conclude with modern African jurisprudence. Of course, like we know that law in itself is dynamic. So the position of African jurisprudence at some point in time has changed, has improved by virtue of the dynamic nature of the society. As we all know that as the society changes, its laws, its norms, and other things like that begin to also change or improve in order to meet the basic needs of the society. So all of that we examine in the course of this discourse. So we'll take the first subtopic, which is thinking about law in Africa. And I will begin by saying that every territory in Africa has at some point been a colony or a protectorate of a country in the West. And it is this relationship that existed between the African territories and the imperial or what we call the sponsoring countries that gave rise to the condescending position held against African nations. So we can submit, therefore, that our colonial heritage or legacy has affected our legal identity. I believe that since we were colonized, if we had a good system that is good enough, then we can't be colonized. For example, the Western world believe that, that hello. So our colonial history has affected our legal identity. And this is not just about Nigeria, but all other African countries that were colonized irrespective of who and who colonized them. And research has revealed that many literature works from the Western world have established what we call an area of dominance around the dark areas of African history. And this action can be triggered or has triggered consistent wrong view and misrepresentation about African law. So therefore, these misconceptions or misdirection or the wrong assumptions that they have about African law can be tagged the mystical representation of African life and philosophy of society. The mythical representation of African life and philosophy of society. And this mythical representation has been expressed and strongly worded in several dimensions, all of which is to perverse the history or the good heritage or the rich culture or the rich law or the rich legal jurisprudence of the African society. So these expressions, the views about the African society, these wrong views, of course, have made it seem that without the intervention of the West in Africa, that there is really nothing to write home about in Africa. Of course, they still hold this view. And unfortunately, so many of us in different ways or areas still support the fact that Africa as a people is inferior. And that's why we discover that our cultures are being jettisoned. Even some of us who prefer to dress, to engage the dressing of the Westerners. Some will say, I don't do native. And of course, that's one of the unique heritage or, that speaks of your heritage as a person. There are different aspects of our life that is unique to us, but we have chosen to follow the ways of life of the West that forms their own common system and choose to drop our own, which is indigenous, unique to us as a people. So all of these views, they are wrong. Wrong in the sense that they are not correct about the African jurisprudence. So we're going to look at the Western scholars' claim or views on African jurisprudence. And I've identified about 4 of them or 5 of them. We will see their view, we will see their position, and then we will be able to make progress in this discourse. So we have, I noted there, Trevor Roper, Angel, Maine, Morgan, and Brelly. All of these are individuals who have at one point in time, made wrong assumption about African jurisprudence. Now, let's start by looking at the view as expressed by Hegel, that is GWF Hegel. What is his own wrong notion about African jurisprudence? Hegel claimed that Africa was historical, meaning that African does not have anything that can even be said to amount to history, or that African lacked civilization, and that Africa or African jurisprudence lacks rational institutions, and in his own position and view, he divided the world into 4 major regions and dismissed sub-Saharan Africa as outside history. Okay? It tried to the entire world, do the entire world, and even not even give it faith to find a place for Africa. He said that Africans were not part of the progression of the spirit and his civilization because they lack law, moral consciousness, and political organization. Those were his views. But between you and I, who have studied and examined African tradition or culture at one point or the other, we have our response to his submissions. But what he does not know is that the African jurisprudence has a unique legal system. In our own form, we have our own infant divination system. We have what we call the account legal traditions and political institutions rooted in oral traditions. And all of them focus on doing justice within our territory. But of course, if it has not come from the Western world, it is believed that it is not superior, it's not fit. That is the view that Hegel held about African jurisprudence. Another scholar known as Henry Maine also had a wrong notion as he saw non-Western societies as satanic and primitive. And again, when you begin to look at the submissions of these scholars, it clearly displays the bias, the hatred they have for African society. The portrayed African legal system as stuck in a primitive stage of development because they feel that because the African system is characterized by kinship-based rules rather than individual rights or contractual relations. Oh, the focus is on the king, is what the king says. But whereas they have even failed to study our history as a people. And I was introducing this topic, I did make mention of the fact that the African jurisprudence is community-based. As a matter of fact, if you delve into the system of dispute resolution in Africa, you discover that it's even the most human-centered system of dispute resolution because the focus of every attempt to manage dispute in the society is for the community benefit, harmonious living in the society. So again, this submission, you begin to ask or determine whether this position or this claim or view about African jurisprudence is right. But the truth of the matter is that Maine and remain disregarded the complex customary legal system that existed in the pre-colonial African society. Of course, they saw that even before they came, we already trading. We engaged in marriage, we engaged in land agreement, and the society continued to evolve. But irrespective of how standardized our system, they think that the system is not standardized. And that's one of the major reasons that gave them the view to have this wrong misconception about African jurisprudence. Now, Morgan is another Western scholar who also had made some claim about African jurisprudence. Lewis Morgan, a, he looked at the stages of societal development. He identified barbarism with Africa, that African way of life is barbaric. And what his view means is that Africa lacked culture and legal institutions that could be deemed to be civilized enough to look like that of the Western world. The question also that you begin to ask, or that should begin to agitate your mind, is if the Western life or model is the ideal model. Of course, some in this class we want to even agree with these submissions. But of course, when I look at the origin of common law system, how what was now later referred to as common law came into existence, we'll discover that these things were rules, regulations, norm, culture of a particular people that guided, the way of life of some people. Sorry, I'm reading the question. Okay. My voice is going high and low, which makes it difficult. All right. I wouldn't know whether it's network, but I'm doing my best here. So, okay. Maybe it's the network of your area, but again, maybe because I'm moving on in the lecture, my voice is going a bit higher and all. But let's see how we can accommodate both. So, again, this submission or this view by Morgan, is it right? The question is as to whether or not it is right can be, answered even by your own perspective. He believes also that the legal structure of the African community is community oriented rather than individualistic. But like I said in the course of my submission, that even the communal life is aimed at enforcing the rights of every member of the society. Then can we say that it is better if it is individualistic, where a one man controls everything that is in the society and makes every other member of the society to be a slave to him? We look at the concept of capitalism, Marxism, and all of that, where in some form, some kind of Western idea. Is that supposed to be the interest of the majority? Okay, so that is another view, another scholar who has developed this wrong view or claim about African jurisprudence. Now, there is Raleigh, another scholar, in his own discussion on international law. He did not in any way recognize the rich culture of the African tradition. He makes the other existing or those that are considered as a standard legal system to be superior. It failed to look at the African customary law as one that qualified to be a law in the real sense of it. Of course, we may not blame them. It is because of the wrong view they have that makes this scholar, to feel that Africa does not have legal tradition on its own, that it only began to develop those traditions when it was colonized. But we submit in this class that these views are historically inaccurate because indeed they do not represent the actual position of African jurisprudence. And that's why Williams Idowu, in his book, African Philosophy of Law, Transcending the Boundaries Between Myth and Reality. That's the title of the book. Williams Idowu, African Philosophy of Law, Transcending the Boundaries Between Myth and Reality. He stated that the myths or the perversions and misconceptions about African jurisprudence are backed up by different arguments, some of which we have pointed out, but we are still going to discuss them in detail for purposes of understanding what we are dealing with. And these myths, perversions, and misconceptions about Africa include, but not limited to, the 7 points that we have listed on this slide that is before us, which we are going to take turn to discuss in addition to what we have said under the various views and submissions made by those scholars that we have looked at. The first one is that Africans do not have a history or a past, meaning that if Africa came from nowhere, a nowhere is something. It's also a beginning of history. So that's their view. Number 2, that Africans have little or no system of laws. Number 3, that African jurisprudence has no respect for individual rights. Number 4, that African jurisprudence is positive. Number 5, that African law lacks unity. The 6th point is that African jurisprudence is rooted in fear of supernatural powers. And number 7, that the African jurisprudence features unrestrained usage of powers. But our discourse on this topic will engage these positions as to whether or not they are true. Let's take on the first one, which is that Africans do not have a history or a past. And I will start by the submission of Trevor Roper. Hello, class. Can you hear me clearly?
Yes, sir.
Yes, sir.
Thank you for the confirmation. So, Trevor, who is a professor of history of Oxford University, remarked, and he said, perhaps in the future there will be some African history to teach, but at the present there is none. There is only the history of the Europeans in Africa. The rest is darkness, and is not the subject of history. Of course, from this submission alone, we could see the bias that the Western world carries against the African society. Of course, The fact that you met someone yesterday, like I remember vividly, I was teaching this course, and it came to my mind while I was in class that the fact that I met someone yesterday, does it, can I say or can I submit that the person was not existing before yesterday? And when you try to answer that question in relation to the submission of Trevor Roper, you will realize that their efforts or the effort of the Western scholars is just to make a mess of the African society. So this statement has sparked considerable controversies and criticisms. So we shall address the inaccuracy, the biases, and the implication of this remark on emphasizing the rich and complex history of African society or African jurisprudence, and it's the fact that it existed independently of the European influence. I submit that African history is rich and diverse, encompassing a wide range of civilizations, cultures, and achievements long before the European contact. Of course, we see examples of the rich African history on our slide. Do we start making boast of the ancient Egypt, one of the world's earliest, oldest, and most influential civilizations, known for its monumental architectural edifice. You look at history, the construction of the temples, tombs built in stone, pyramids of Giza. These were built with a distinctive repertoire element of the Egyptian origin. Their indigenous wisdom and knowledge and expertise, probably because they were not referred to as engineers, structural engineers. They were not referred to as architects. They were not, so whatever they did not amount to anything. But the truth remains that all of these things are still in the record books, and they speak of the rich culture of the African society. If you want to talk about the advancement of the Egyptians in writing, in mathematics, or medicine, all of those can be found there. Or look at the kingdom of Kush, known for its powerful rulers, great minds, people who were responsible for more than 200 pyramids. The kingdom of Kush were also known for their cultural achievements, and they play significant role in ancient African history. What about the great Zimbabwe? A medieval city that was the act of a vast trading empire, showcasing advanced stone constructions and urban planning. It's also known for its impressive stone structures and forms of engineering or of science, which the Western world have failed to identify with. We want to talk about the Mali Empire, renowned for its wealth, particularly during the reign of Mansa Musa, that is the African emperor, and his center of learning like Timbuktu, the Timbuktu Learning Center. You go to the Empire of Ghana, you see a lot of our, wealth, whether in terms of knowledge, in terms of what we have done strictly. In all of these things, they never look at the other aspect of our history.
Actually,
About
no pass like that. If you lay, you better go wala about what you want.
all right, we are noting what all you are saying. Okay, so all of these are things that ought to have been considered before making their wrong perception about us. They dismissed our oral histories. They didn't know that Africa preserved its history through oral traditions, which are as valuable as written record for understanding the past. We have our own history that tells our story. The fact that yours is written does not make the African history to be less. You have our African history, we have which include stories, poems. In Yoruba, we have what we call the orikis, and even songs. For example, when the drum is talking, this is the one we call talking drum. And I mean, when they are laughing, for example, in those days, it's in an occasion, and they do not wish to speak to him, by to make others that are around him to understand. The talking drum speaks to the king. His drummers will use the talking drum. That's why they call it talking, because it speaks. They remind him of what he must do or do not do in public. They remind him of what that they have fought and won and challenges. And they praise him, they tell him, which makes the African society very unique. So I don't need to come and tell the king with the words of mouth before you understand what he needs to understand in public. And that's, of course, that's what they call ethical conduct, or what they call etiquette today. What about our rich proverbs, cultural values, and societal structures? Again, these individuals that claim that Africans do not have history or past, they have ignorance of African contribution. Even with all that we have discussed so far as examples of rich African history, they ignore the African contribution on global culture, science, and technology. Because one, they don't know, or they fail to acknowledge that ancient African society were involved in early metallurgy, the process of involving melter, usage of melter, agriculture, and development of sophisticated political systems. One of the things that you would notice in African jurisprudence is that Africa also had a special way of dealing with its own system, especially in crime and other areas of its life. All of these contributions are essential part of world history. And when we look at the system of dispute resolution in Africa, where people gather and to have discussions, what is the difference between those activities and what we call the alternative dispute resolution of today? We talk about mediation. Oh, probably because we have given it a more refined name. But all of these are things that originated from the African history. What we can see basically from the position of Trevor is a total bias for the African society. The truth is that African society has contributed greatly to the world history. Now, that's for number one, misconception or claim. Number two is that Africans have little or no system of law before the arrival of the Europeans. This view, I would say, stems from Eurocentric biases and misunderstanding of African governance. It's a pure bias, pure expression of hatred for the African society. So, this notion is wrong. I submit that European colonizers frequently dismiss or misunderstood African legal practices because they differ from European legal traditions. This dismissal was often used to justify colonial rule and imposition of European legal system. All of this is to still till tomorrow to justify why Africans were colonized. And of course, it's just a display of, bias against the African nation because that they believe that there is a general assumption that the paraphernalia which they associate with law and are deemed, their own law are deemed to be absent in the African setting. Because number one, as at that time, there were no formal legislature, as at that time, no formal courts, and sophisticated legal officials, like the judges who will come out dressed in black, put one white thing on their neck, put their wig, just like we have in the system today. Thank God for some African nations changing to local attire, making the judicial system to wear their own indigenous attire rather than still glorifying the one that were handed over to us by the colonial masters. Look at the submission of Driebeck in his book. He said, African conception of law. He submitted in the African, that's the title of his book. He submitted that, generally speaking, symbols of legal authority, e.g., police, prisons, are completely absent. And in the circumstance will be obtuse. You see, prior to their arrival, the African society, when you do more research, you will see that each of these society had their own police system. We have the age grade in our own history as a country, Nigeria. The age grade, they serve that purpose of policing the society. Even it's also believed that the spiritual also manages the affairs of man. But these assertions are unequivocally false. Because, like I said, numerous societies had well-established legal system and governance structure before we came in contact with the Europeans. I'll give you some points to refute these assertions. I'll talk about the sophisticated governance system that we have. The customary law regulated communities. We have examples in Mali, in the Igbo system of governance, the Somalia, Ashanti Empire, Benin structure, court, and so on and so forth. let's just talk briefly about the sophisticated governance system. I submit that many African societies developed complex governance structures, including kingdoms, empires, city-states. Each had their own legal code and administrative structure. Like the Kingdom of Mali, for example, is known for its well-organized administrative and legal system, which included various levels of governance and a code of conduct that regulated societal interaction. Is it contract? Is it marriage? Is it land ownership system? Is it even ascension to governance? All of these were already in place. What do we say about the Great Benin Kingdom? Had its own sophisticated system of governance, with also a very highly well structured system, and they have their own law. And if not so, why were the British requesting for a series of treaties to enable them to have access to the commodities in the territory? These are these are things to show that the Western world, they are in actual or real denial of reality. We talked about the Ashanti Empire, which featured a centralized government with codified law and council of elders who played significant role in legal matters. Like I said earlier, some of the systems we have as alternative dispute resolution today began from African ideas. Oh, probably because we now have negotiation in an air-conditioned room where parties will sit on well cut out chairs and tables with microphone, with AC, with automatic voice recording, and then it's different from what the communities used to have, where they will sit, their leaders will sit, people who serve as mediators, who serve as negotiators, who serve as conciliators. All of these were, were part of our system, and they were indeed unique. Then, what about our traditional legal system? Like I said, I submit also that African society often rely on customary law, which was based on tradition, custom, and norms that have been passed down through generations. These legal systems were enforced by community leaders, elders, even the councils, and they covered different areas of life, like I said earlier. Let's even come home. Look at the Igbo people of Nigeria. They had a governance system and law based on consensus and the authority of the elder. Their customary laws address issues such as land ownership, marriage, trade, and so on and so forth. The Igbo people could manage their life based on their own system that were as the consensus system. The Somali people practice what we call ZEER, as in XEER. Is a traditional legal system that governs clan relationships, resource management, and conflict resolution. These are not communities that are just in one place, but spread all over the African territory. Like we said of the Igbo people, they operated the highly decentralized system of government or governance, where village assemblies, the likes of the Ohanese, play central role in decision making and dispute resolution. And the good thing about this system is that those systems were effective enough to manage the various disputes between the society. And all of these, make our system to be very unique. We have the legal codes and documentation. Some African society had written legal codes long before the European colonization. Example, we have the code of the Congo Kingdom, Angola. The Congo Kingdom had a written legal code that regulated various aspects of life, including crime and punishment, property rights, and social behavior. What about the ancient Egypt? Like rightly submitted, it's known for its detailed legal system that included written laws, which also covers property ownership, property rights, contract, family law, and criminal justice. And like I said earlier, our oral history is also part of what makes our system to be unique. We have the proverbs and sayings, which are used to teach and reinforce legal norms. They were the things that helped to mold the society. Oh, we will not say that, okay, then we didn't have things like moral decadence or crime, high rate of crime in the society. But as sophisticated as today's world is, what kind of comparison can we make about the rate of crime as of now and what it used to be in those days? So we do not agree with this view that Africans have little or no system of law before the arrival of the Europeans, because the African society had a diverse and complex system long before the European colonization. And this system were deeply embedded in their cultural, social, and political structures. And they demonstrated rich legal heritage that deserve recognition and respect, unlike the lies that are being told, by the Western views. That's for number 2. Number 3 is that African jurisprudence has no respect for individual rights. This is also one of the views. Okay? No respect for individual rights. That African system is based on communism. This is also what we can refer to, all this view that African jurisprudence has no respect for individual rights can be classified as a wrong, sweeping generalization and misrepresentation of the African legal system. The truth of the matter is that human rights were highly enforced under the indigenous African society. And like I said before, that African society traditionally emphasized communism, that is collective and individual harmony. That doesn't mean lack of respect for individual rights, but rather a different conceptualization of right within a community context where every member of the society is important. Meaning that the society should be put first. And then when you look at the system as it relates to our criminal jurisprudence right now, that if Mr. Johnson Omole committed a theft, that theft is not seen to be against the primary owner of that property. the theft is seen as a disregard, is seen as a slap on the face of the society. And that's why the state takes over prosecution of such cases. Is it not to protect the individual? If Mr. Johnson Omole is not stopped, he will continue to violate other individual rights in his society. So therefore, the origin that African jurisprudence, embraces communalism in terms of enforcing human rights is then unique because it's even more result oriented and to focus on just one individual. So, like, of course, okay, let's even address their position right. Customary law often include mechanisms to protect individuals, such as the right to fair treatment, the resolution of disputes through dialogue and consensus, or the doctrine of audiotarem patem, which form part of the celebrated system of justice, were also part of the African system. And that's why the Yoruba adage, I don't know, those that know how to speak Yoruba very well, we be able to interpret it that it's only a wicked elder that will listen to one side of the story. Àgbà òṣìkà ló ń gbọ́ ẹjọ́ ẹnìkan gbọ́ or something like that. Does that not speak to us? That's a saying. That's one of the rich cultural heritage of the African society. As we have it in Yoruba culture, I can't say it from that. All other cultural communities, ethnic groups will have similar views, and they resolve issues at the community level through dialogue.
You want just to pretend like you want to use it.
Among the Yorubas, there are specific roles and responsibility that ensures the protection and welfare of individuals within the community. The Igbo people practice the Igbaundu. I don't know if that's the actual pronunciation, which involves oaths and agreement that safeguard individual rights and ensure mutual respect. What about the concept of Ubuntu, prevalent in many Southern African culture, and it emphasizes human interconnectedness and dignity. So what exactly informed their wrong views? I can submit that it was lack of detail or lack of failure to study the African society. So this assertion that African jurisprudence has no respect for individual rights is an oversimplification that fails to appreciate the depth and diversity of African legal tradition. And its truth is that African jurisprudence encompasses values and principles that do not respect individual rights within a community, that does not focus basically on individual, but individual and the society. Because what makes up the individual, what makes up the community? It is the individual. It encompasses the value of Africa, the respect for individual, and also communal living. So all of these are submissions to, to silence this misrepresentation about the African society. Now, let's look at the fourth one. If you have a question, you can do well to, probably send it to the question and answer section, or when I'm done with my lecture, then we could interact. So the fourth one is that African jurisprudence is positive, not negative. What do we mean by this? Now, this is another claim that is only concerned with how people should behave in a society, not the penalty for crimes committed. Hello, class. Can you hear me, please?
Yes, sir.
Yeah, we can hear you.
All right. Sorry for that break. So, African jurisprudence is positive, not negative. It is claimed that African law is only concerned with how people should behave in society, not the penalty for crimes committed. How true can this be in view of the various submissions we have made on the position of African legal system? And of course, this view was propounded and celebrated by Dribeg. According to him, Dribeg, as in Dribeg, he said that African criminal law only directed how people should behave towards one another, neglecting in the process the punitive aspects of law. That is a very weak view of African jurisprudence. What he's saying is that African system consists of weak instruments for containing crimes and criminal offenses in the society. And it's of the view that the capacity for enforcement in African law is lacking or substantially eroded. This falsity of this charge against African law is very obvious. This wrong perception is indeed very obvious. Now, how true is this? We say that the issue of punishment is not taken lightly in African law. The idea of punishment in African jurisprudence transcends the concept of punishment found in Western penology. Whereas Western penology, that's a system of punishment, sees punishment only in the light of the offender. The idea of punishment for crimes in African philosophy of law and society touches not only on the immediate offender, but also on the family and the community where the offender is necessarily a member. Meaning that, the focus is to ensure that the individual learns his lesson so as those who live in the same society with him. So he said, laws, he said, thou shalt, that is the focus, thou shalt not. But first to talk about the punishment. But the truth of the matter is that African jurisprudence focuses on social equilibrium and societal harmony. To see that, the person who has done wrong is punished, the society does not continue to suffer from his wrongdoing, and so on and so forth. And like we have rightly pointed out, if an individual commits a crime, there are procedures within the system that helps to resolve all of this. We have our procedure on arbitral and conciliatory system of dispute resolution. And there were quite a lot of sanctions that were in place. Now, in the African traditional society, even when we look at Nigeria, for example, that if a man chooses to do something that is against the society, in those days, the shrines were there to curb excesses. Well, before they even take them there, some of them will confess their sins. And even in the indigenous African society, punishment like ostracism, or popularly called banishment, and so on and so forth, also held sway. So it is not correct that African law is positive, not negative. One of the major focus of the African jurisprudence is not only retributive but restorative. And we have examples of the various sanctions that existed that is still existing: ridicule, restitution, supernatural consequences, and so on and so forth. For this particular submission, we disagree with their position. And the fifth one is that there is no such thing as the unity of African law among others. This view holds that African legal systems are so fragmented, diverse, and localized that they cannot be spoken of collectively as African law. This is sometimes it's laughable when you hear this submission. Must there be we have English law. English law is not just one. When we talk about receiving English law as one of the sources of Nigerian law, we talk about common law, talk about doctrine of equity, talk about statute of general application. All of these are combinations of English law. So it will show that indeed this various wrong perception about African law is nothing but a lie. They argue that because those laws are community-based, they cannot be said to form, what can be referred to as law indeed. And of course, all of this idea is just to undermine the legitimacy of customary law and justify the imposition of colonial legal system as a modernizing necessity. But they deny the philosophical depth or systemic character of African jurisprudence. Like we have seen how they deal with various issues. But of course, our own is to set the right story in place. So, therefore, this perception is also wrong about the African jurisprudence. So, therefore, the fact that our law is not put in one place does not make it less of a body of law. Okay? But all of these submissions were just an attempt to divide and rule us and infuse their own system of law and make it more, superior to ours. But these lectures are there, and other scholarly work are there to correct this wrong notion. Another misrepresentation is the African jurisprudence is believed in fear of supernatural powers. Look at what Paget said. He said, in tribal society, law is governed not by logic, but by fetish. So the tribe trial by fetish is just, and trial by reason is unjust. It is futile to seek a reason in tribal justice as it is not rational. Now, the African system is what is referred to as tribal justice here. But the truth of the matter is that this misrepresentation about African law is absolutely unfounded in reality and clearly not in conformity with the state of affairs in the African society. And it may be said that, oh, yeah,
Excuse
please,
me,
can
sir.
that person mute his device so
Sorry,
it doesn't affect?
sorry, excuse me, sir. The chat is locked. We cannot sign attendance, sir. I'm sorry for interrupting.
You are not the one to determine when you sign attendance. I am in charge of my class, please. So, the belief that people believe or people engage in uh, fetish, or maybe by going to a shrine to make people swear, to make people say the truth, and all that, make our system to be uh, barbaric. Of course, that's what they think. But again, that does not represent our own system. The laws of the people, of the indigenous people, are obeyed for the good of the society. And lastly, we talk about the unrestrained usage of power. This is another misrepresentation, another lie about the African jurisprudence, which is not correct. We submit that the various societies had their own popular assemblies where matters are decided, regulated, where chiefs, elders express their view and provide solutions to disputes. But because our own system, or the African system, was not, well, was nothing like formal legislature where some people sit in the hollow chamber to decide and all of that, then it's not a proper system. There's no parliament, nothing to show. But the truth of the matter remains that without the chiefs in the society handled all of the issues in what sometimes is called the tribal assembly, or even some other practices that engage the elders in council, and so on and so forth. So, to draw a conclusion on this, T.O. Elias, against all of this representation, said that the differentiations between African laws and the laws of other people is only superficial. So what does this mean? There is no need for the differentiation. These are people of different race and culture. Consequently, we say that African jurisprudence itself is unique because it has bettered all other modern dispute resolution mechanisms, like what we are proud of today: mediation, negotiation, conciliation, arbitration, and all of that were products of the African race, were products of African idea. So with this, we hold this special view that indeed African jurisprudence is unique, without anybody trying to in any way rubbish what has been a source of major contribution to the world history. So with this submission, we will have addressed this aspect of the lecture. And because of our time, we'll stop here. When we have opportunity again to continue in our lecture, we'll take it up from there. We make room for questions. And again, we can send in your attendance via the chat box, which is now enabled. And and then we will take questions if we have any. Just a minute. And also, please, you can send in your attendance now. Please note that one person per device before it can be counted. So I will open the floor for questions if we have any. Any question? Any question? Okay, so in the absence of question, I believe the...
I'm sorry, sir, please, can you add slides?
Well, now, thank you for that. Good morning, sir. Good morning, sir.
Okay, I can see some questions in the question and answer part of the platform. Please, okay, person said, what is the name of the last scholar you mentioned? I mentioned several scholars. I can't really, point out which one you'll be referring to. But the good thing is that this lecture is recorded and is on my YouTube platform, so you can go there, listen to it over and over if you so desire for your readings and all of that. So, is there any other question relating to this topic?
Yes, sir. Good morning, sir.
Good morning, sir. Please go ahead.
Good morning, sir. Good morning, sir.
Yes, I can hear you. Please go ahead.
Okay. Sorry, sir. It's not directly a question. It's a comment. Sir. I wish to acknowledge that. I wish to acknowledge and thank you, sir, sincerely for this well-researched topic. I also wish to add in the works of Walter Rodney in his book, How Europe Underdeveloped Africa. So that has been